Good afternoon, everyone, and thank you for joining us for today's webinar, Superannuation Splitting Orders, Drafting Tips and Pitfalls, which is part one in our two-part series on complex issues in property and financial matters. Before we start, I'd like to take a moment to acknowledge the traditional custodians of the lands on which we're meeting today, and I pay my respects to all elders past, present and emerging. I'm dialing in from Sydney, so for me that's the Gadigal people, and I extend that respect to all Aboriginal and Torres Strait Islander people present today. My name is Dina Palethorpe, and I'm the coordinator of LEAP's new Family Law Forum, which is our dedicated educational platform. We are so pleased to be able to offer you with such great webinars like this one. And if you have any requests for topics you'd like to hear about, please do let us know. Today's session is going to be presented by two outstanding family lawyers from Lander & Rogers, Liz Coford and Grace Hurley. Liz is a partner and accredited specialist in family law with extensive experience advising on complex property matters, financial agreements, and superannuation matters. She's known for her clear, practical approach and her deep understanding of the Family Law Act. Grace is a senior associate who works closely with Liz, and she brings sharp analytical skills and hands-on expertise in both litigated and consent matters. Together, they make a formidable team when it comes to simplifying and navigating complex financial matters. Today's webinar will give you a practical overview of superannuation splitting orders, from the key legislative framework to the essentials of drafting effective orders. Liz and Grace will walk us through the basics of superannuation, drafting tips and common pitfalls to avoid, and some of the complex issues that can arise with self-managed and defined benefit funds. We'll finish with a few case examples and practical takeaways you can apply in your own matters. This session counts as one CPD point and will go for an hour, which includes about 10 minutes of questions. Please feel free to post your questions in the Q&A box as we go. We'll try to address as many as possible during the webinar or at the end. The session will be recorded and sent to you after the session along with the slides. Without further ado, it's my pleasure to hand over to Liz and Grace.
Thank you very much for that warm welcome, Dina. It's a pleasure to be joining the Family Law Forum team this afternoon. When Dina told us how many people were interested in superannuation on a Thursday afternoon, Grace and I were quite overwhelmed. So we hope that today's session can be practical and useful for you. And as Dina said, we welcome as many questions as you may wish to ask. You don't need to wait until the end. We're very happy to take those as and when they arise. Grace is going to be starting with our overview slides, and then we'll hand over to me for some drafting pitfalls and other tips. We'll just get our slides. Hopefully everyone can see those. Just pop a note in the chat if there's any issues from anyone's perspective, and we'll get started. So thank you.
All right, welcome everybody to our superannuation presentation. Today we'll be going over 6 main topics, which you can see up on the slide there. We will pause for questions after we have gone through the 6 topics, and then if we have time, we will go through some case examples. All right, so we will quickly rush through the refresher slides. As we all know, super is money contributed by an employer to their employees over their working life. Employers are legally required to pay a minimum amount based on the super guaranteed rate of the ordinary earnings, which is presently at 12%. Employees can also deposit additional amounts into their superannuation, and this is currently up to $30,000 per annum. Employers have their default fund. However, as we all know, employees can select which fund they prefer for their entitlements to be paid into. It is possible to have more than one superannuation fund entitlement. And the scheme, as we know, is designed to provide Australians with income in retirement and to reduce the reliance on the age pension. Super, as we know, cannot be accessed until a condition of release is met, being the member reaches 65 years or retires at 60. Super can be released as a lump sum, converted into a pension stream, or a hybrid of both of these arrangements. So what are the types of superannuation funds? There are three main types of or categories of superannuation funds which are relevant for family law purposes and our matters. Most Australians will hold their superannuation in an accumulation fund. In these funds, members' funds are pooled and managed by the trustee. The member entitlement accumulates over time through additional contributions made by the members and investment returns. Member entitlements are easily ascertained through statements, through the financial disclosure process, and evaluation is generally not required for family law purposes. A small number of Australians hold their entitlements in what is called a defined benefit fund. For example, emergency service workers, police, and politicians. These funds can be quite complex, and Liz will run through some common pitfalls and some tips when dealing with defined benefit funds. A retired benefit is determined by a formula rather than investment returns. And this formula is generally a multiple of the employee's years of service and their average final salary. Evaluation is required for family law purposes, and it is very important to take careful note of the relevant deed for the particular defined benefit fund when drafting superannuation orders. The last main category of superannuation fund that we come across in our matters is obviously self-managed superannuation funds, the members generally being the husbands and wife, and valuations may be required in our matters, or at least of the assets held within the self-managed super fund. So I'll quickly go through the legislative framework for the superannuation scheme in Australia. By way of background, prior to December 2002, superannuation entitlements could not be split at all. Adjustments to the non-superannuation pool in family law matters were made to accommodate the differences in each party's super balances. After December 2002, amendments were made to the Family Law Act to define superannuation as property, enabling it to be the subject of property settlement orders, meaning the court had jurisdiction to treat superannuation as property. However, this does not mean that it's treated the same way as other property. Superannuation splitting orders are made pursuant to the powers in Part Roman numeral 8B. However, the jurisdiction to make these orders relies on the statutory extension of the matrimonial or de facto cause, investing the courts with power under Part Roman numeral 8 and Part Roman numeral 8AB. This was explained by the full court of the Family Court in a case called Rahman and Rahman, 2020, where the wife sought superannuation splitting orders after a Section 79 property settlement orders had already been made. This meant that the court's jurisdiction had already been spent, and the wife had no jurisdiction to make this application, and her application was dismissed. As super is treated as property, the Section 79 process or Section 90 SM process for de facto matters with respect to property settlement matters must be followed before a superannuation splitting order is made. This requires the superannuation to be identified and, if necessary, a determination as to value made, contributions, and current and future circumstances assessed. Despite this, the general approach in Victoria is that the parties' superannuation entitlements are equalised. However, in accordance with the property settlement provisions and taking into account the nature of the superannuation, whether there is a split and how much the split is will vary from case to case and will depend on the circumstances of the matter and the financial objectives of your client. Now, to understand the drafting of a splitting order, it is important to understand the manner in which the Family Law Act, the SIS Act, and the SIS regulations and the various trust deeds work together to achieve the splitting of superannuation. The Family Court's power is not the power to split the underlying superannuation interest. It is instead to order the trustee to split the payments arising out of the interest, as and when the payments are made by the trustee under its particular governing rules. The splitting of superannuation is a two-stage process. Stage 1, an order or an agreement under the Family Law Act is made directing the trustee to split a superannuation interest. Stage 2, the actual splitting of the super under the SIS Act and the SIS regulations, or under the specific deed or legislation that applies to the particular superannuation fund. The trustee's payment splitting obligations are a mandatory element of any splitting order. If they are absent, the order is not a splitting order in accordance with Part Roman numeral AB. So on to some drafting tips in relation to superannuation splitting orders. What are the types of orders that are available for splitting superannuation? Section 90XT of the Family Law Act enables the court to make payment splitting orders. There are 3 types of payment splitting orders that the court can make. The first type is an order which allocates a base amount. This is under subsection 1A of section 90XT. For example, a payment split of $100,000 out of the member entitlements of $200,000. The second type is an order which prescribes a percentage. This is pursuant to section 90XT 1B. For example, a payment split of 50% out of the member entitlements of $200,000. The third type is an order which is very rare, not one that we come across very often in our matters, is one which prescribes a percentage in a percentage-only interest. For example, a payment split of 50% out of the member entitlement's 30% interest in the fund. As we know, it's possible to split in both the accumulation phase and in the payment phase of a superannuation interest. Before making a superannuation splitting order, a determination as to the value of the superannuation entitlement must be made under section 90XT2 of the Family Law Act. So the 4 key elements of drafting a super splitting order. In any type of order, the 4 key elements are as follows. The first is that the order must allocate a base amount or prescribe a percentage. Secondly, the order must order that the non-member spouse has an entitlement to be paid from the member spouse. Thirdly, it must order that the super trustee calculate the entitlement of the non-member spouse in accordance with the regulations and pay the entitlement when making a splittable payment. And finally, the order must set an operative time. Now, an interesting case on the slide is Stevens and Stevens 2005. This is a particularly good reference case for examples of deficiencies in a splitting order. In this case, there were 3 main technical defects in the order which needed to be corrected. The first was that the order failed to identify what the type of order was being made under section 90MT, which is now section 90XT, the 3 types we just went through in the previous slides. The order provided that the interest of the husband in the superannuation scheme shall be split, whereas as we've discussed, the power of the court to make the orders is limited to splitting payments rather than actually splitting the superannuation interest. The entire order was expressed to bind the trustee, including clauses which were of no concern to the trustee and in relation to the wife and the husband's conduct. And The trustee in any order, superannuation splitting order, should only be bound by those clauses that relate to the trustee's obligation. So I'll now go through some examples of the two main types of superannuation splitting orders that we come across. So the complete wording of section 90 XT1A is up on the slide there. And when you read through the section in full, it's clear that the order must do the following. Firstly, it must allocate a base amount as a cash amount. Secondly, it must award an entitlement by an amount, not a percentage, and it must bind the trustee. In any type of superannuation splitting order under this section, the trustee is bound to calculate the entitlement of the non-member spouse and pay the entitlement. So up on this slide, I've put together a precedent order for a section 90 XT1A splitting order. You can have a look at these slides at a later time and use these for any matters. Now I'll just move on to now here is another precedent order for a percentage-based splitting order, so pursuant to 90 XT1B. It is important to note when looking at these precedent orders that each industry super fund has its own particular requirements and sort of their own preferences in superannuation splitting orders. And it's always important to review what the particular superannuation fund is. And each superannuation fund often has some tips and examples on their websites, which you can view. Particularly the name of the trustee and the fund can often come back with requested changes. So it's important to keep that in mind. So what is the concept of operative time in a superannuation splitting order? The operative time is the date at when a trustee must start to recognise the interest of the non-member spouse, being the point when the payment split actually occurs. The amount payable is calculated as at the operative time, even if there are delays in implementing the orders. For splitting orders, there is actually no requirement that the operative time be the beginning of the fourth business day after service. This is only a requirement for superannuation agreements rather than orders. In practice, however, the trustee will often object if the operative time is before the date that the orders were served on the trustee. So procedural fairness and some practical strategies for engaging with trustees. A superannuation trustee is not a party to a marriage or a de facto relationship and therefore is not a party to the proceedings. However, Section 90 XZD of the Act provides that an order can bind a super trustee if they have been accorded procedural fairness in relation to the making of the order. Super trustees must be notified no less than 28 days in writing before any order is made in relation to an eligible super plan. Any procedural fairness letter must include the precise terms of any order which is sought to bind the trustee, the next court event, if there is one listed, notice that the parties intend to seek the order if no objection is received from the trustee, and notice that if the trustee objects to the order or any part of the order, that objection must be given within 28 days. The relevant timeframe for any objection from the trustee is 28 days. If the trustee does not respond or does not object within this time frame, procedural fairness is taken to be affected. Practically, procedural fairness simply involves sending a letter to the super trustee with the proposed super orders and inviting any objection they may have within 28 days. The letter should include details such as the names of the member party and the non-member party, dates of birth, and the member number. A copy of the procedural fairness letter and any response received from the trustee should be filed with the court together with any application for consent orders. Once the orders have been made, a certified copy of the sealed orders must be served on the super trustee. Some funds accept certified orders via email. However, some, including, for example, Australian Super, Rest Super, Post Plus, HESTA, and CBUS, to name a few, require a hard copy of the certified sealed orders to be posted to them. Practically, it is best practice to email and also express post hard copies of the certified sealed orders to the super trustee to avoid any delays. It is then a matter for the super trustee to implement the terms of any super order. Each fund has their own forms, which the non-member spouse will be required to complete. So I'll now hand over to Liz to discuss some common drafting pitfalls in super splitting orders.
Thank you, Grace. It's a great segue, actually, because the common drafting pitfalls, as we most commonly see them, arise in SMSFs, so self-managed superannuation funds. And I think a large part of that is the absence of that procedural fairness process. So there are a number of reasons why we sometimes see these drafting pitfalls, but certainly I think the main one is without that professional trustee or an in-house team that looks after procedural fairness for a super fund that is there to receive and approve the orders, there is no sort of check and balance on what we see happening in the world of SMSFs. So moving to the next slide. One of the most common errors is failing to reflect the fact that procedural fairness has been afforded. And of course, we know with SMSFs, the trustees are usually the parties themselves, which can be helpful insofar as you don't need a 28-day time period up your sleeve or awaiting a response, even if it comes back in a shorter time frame than that. But it can mean that the orders are deficient in recording or reflecting this fact because people adopt a more sort of casual approach. Parties can confirm that procedural fairness has been afforded in a personal capacity, or it's more common to see it being afforded in their capacities as directors of the trustee company of an SMSF. But this should be reflected in both your super splitting order itself and in a notation to the orders. So I've popped an example on the slide of some recommended drafting to ensure that you capture both the fact of procedural fairness occurring and also the parties' recording of the same. And that avoids the need for a separate document in writing that the parties would be recording elsewhere in their capacities as trustee to reflect that procedural fairness as having occurred. The order is quite a simple one, and we see this, it's in similar terms to orders for non-SMSFs having been afforded procedural fairness. These orders bind the trustee. But the important notation reflects that the applicant and the respondent in their capacities as directors acknowledge having received procedural fairness in relation to the relevant or operative paragraphs. That's a slide you can use for SMSF splits. Another common pitfall we see is failing to actually provide a valid superannuation splitting order. Again, I think this is because our orders aren't sort of put to their proof through a procedural fairness review on the part of a super fund trustee, but you often can see some pretty sloppy drafting in relation to SMSF super splitting orders that really look more like a heads of agreement. The first example, in fact, that I've put on the slide is something I saw in a matter. In this matter, the parties had a roughly sort of equal balance, each of them, in their SMSF, of which they were both members. Their balances were about $30,000 apart. but they weren't precisely equal. And there was an understanding in that matter that the parties would top up one of the members' balance up to the concessional contribution limit to achieve equality, because you can put up to $30,000 in contributions in a given year. But we couldn't really be sure that that would happen. And there would be, of course, a further set of financial accounts required before a superannuation split could be effected, which is common practice in SMSFs. So rather than saying in the event they're not equal, the parties do all acts and things to ensure, the preferred approach is to use a split to be a legal split of precise equality via a formula, which is essentially an equation. This equation allocates the base amount under 90XT4. And once you have done that, you can then go ahead and use your standard 90XT1A super split. So lawyers hate maths, but it's really a quite simple way of saying that we are trying to equalise, or here I've just multiplied it by 0.5, the member entitlements, and what needs to be paid is half of the total entitlements minus the amount that the party with the lesser balance already has. This is also useful in cases where there's an agreement to retain specified assets within an SMSF. So it's not uncommon for a super fund to hold property from which a business operates its premises. And then sometimes there are other assets as well as that business real property, such as cash and shares. And I like to guard against sort of volatility in share prices between the date of the mediation and the date of implementation of a splitting order. And I find that the formula, such as the one that I've put on the slide, is the safest way to do justice and equity between the parties. So moving to the next slide, and I'll try and move through this perhaps a little bit quickly so we've got enough time for some questions, but dealing with some complexities that arise in defined benefit schemes, SMSFs, or cases involving death or serious illness, I should say, of a member. Look, each one of these topics could be their own separate hour-long presentation. So I'm just going to make a few key points about each of these, and then we'll move on for some questions and case studies. Grace has already given you an overview of the defined benefit fund regime and the fact that valuation evidence is what we need in order to deal with these types of superannuation interests. One of the most important things in terms of complexity for these defined benefit funds is they're not regulated by Part 7A of the SIS regs, which are the provisions that facilitate the payment splits and sort of govern how new interests in funds are created for non-member spouses. And instead, it's the specific trust deeds within defined benefit funds that determine what effect a super splitting order has on the calculation, that formula Grace was talking about, of a member's ultimate entitlement at retirement. And so really the importance of understanding what's in these deeds can't really be emphasised enough. And this was highlighted in a reported decision of Bilal and Bilal, which was part of a string of cases that mostly dealt with superannuation. The husband in that case had made contributions at a rate of 10% of his salary during the relationship, and then 2% of salary after separation. And the full court agreed in that case that the trial judge fell into error by failing to refer to the particular nature of his interest and the specific evidence about the increase in the value of the fund over time and how that had been derived in terms of those contributions. There's a couple of paragraphs I put on the slide that I think are really worth looking at. What the full court says is that it's fundamental to a consideration of any proposed order that the court consider the governing rules of funds within their specific deeds. And it's those rules which determine the effect of any splitting order on the underlying interest in the fund. And goes on to say that it's an error both to fail to consider the specific requirements and ramifications of the deed's provisions and to assume that the effect of a 90XT1A order on the husband's defined benefit interest is the same as it would be if he'd held an accumulation interest. And conversely, it's also an error to assume the effect of such a splitting order on the non-member spouse is the same. because it's the terms of that deed, the defined benefit funds deed, that will dictate the variables by which the present and future benefits are calculated. And the deed dictates the nature, form and characteristics, therefore, of the interest that the wife will acquire. And the full court concludes by saying that justice and equity of any proposed splitting order, you basically can't look at that without reference to both of those factors. Moving on to the next slide. On the topic of complexity in SMSFs, as we know, these types of funds can hold assets that the parties specifically wish to retain, such as listed investments or shares, but equally there can be a disinclination on the part of a party who's exiting an SMSF to go off and establish their own self-managed superannuation fund. And where that's the case, we see that cash is the preferred source to effect a super split. The compliance costs of maintaining your own self-managed superannuation fund is probably one of the main reasons why parties don't want to do that. There's a requirement, as we know, to prepare SMSF returns and financial statements each year, but importantly to meet the costs associated with mandatory auditing of those records on an annual basis. Most accountants will tell you that it's typically not worth it for a client with less than about $500,000 in super, and many of our clients separate at a point before they've accumulated an entitlement to super in that sort of quantum. And so for this reason, we see a split and then roll out to an accumulation fund from SMSFs as probably the most common method in these types of cases. But importantly, we do want our orders to reflect what the agreed arrangements are and to state with specificity what the parties should each do. So, for example, if one party is taking cash and rolling that amount into an accumulation fund, the order needs to provide for that. So we would have the parties doing all acts and things necessary to cause her member balance in the SMSF subject to a splitting order, assuming you've had to do a super split and she's not just keeping her existing member balance. And I like to define that. So I'll say she has her existing balance plus the split provided for in the orders, collectively the transferable benefit to be rolled over to a complying fund of her nomination, that she's at liberty to request that as defined, to be procured by way of cash from the SMSF, and that the parties do everything required as directors of the trustee of that SMSF to discharge the obligations under that order. The other thing to think about is if your client is taking an in-specie division and transfer of assets held within the SMSF that was conducted during a relationship and then setting up their own SMSF, you want to make sure that they receive assets that aren't the ones loaded with the lowest cost base. And instead, that is for tax purposes. Instead, you want to make sure that the division is shared across both parties. So particularly if there's been a long history of dividend reinvestment in a fund, then you'd consider an obligation to ensure the rollout of an in-specie division of each individual parcel of shares as historically acquired by the fund by reference to their cost base for capital gains tax purposes. It's fine if all of the shares were bought in a single tranche, but we know that in reality that's less common. And if you draft your order by reference to the historical cost base for CGT purposes, if your client then wants to go and change their asset allocation within the fund as time goes on, they're not going to be at a disadvantage compared with the other party. Moving to the next slide on the topic of complexity. The reason that I guess we're interested in death or serious illness when it comes to super splitting orders is that many insurance policies that respond to death, trauma, or TPD or total and permanent disablement are held by superannuation funds because it's, of course, a tax-effective way of paying your premiums. You can do it from pre-tax rather than post-tax income. And as we know, many funds have automatic insurance that people never bother to opt out of. So in unforeseen or unfortunate events of death or serious injury, super funds can really become the focus. And one case that I came across while preparing for today was exactly that scenario, a case of Brannick and Sandberg. It was a case where the pool excluding super was only around $890,000. So the overwhelming majority of the assets, 1.57 million of the assets, arose because of the wife's TPD and subsequent death. In this case, as is very common, the policy was held in an SMSF. It was that fund that had paid the premiums, and the evidence before the court was that the decision to buy the policy within the fund was a joint decision based on financial advice that the parties received from a jointly engaged financial planner. The court assessed contributions to the super pool on a 75-25% split basis in favour of the wife, and provided the husband, and that assessment on contributions provided the husband with a 35% split of the global pool, and the remaining 65% of all of the assets on a global basis went to the wife's estate. And what was clear in that case is the wife had put her affairs in order following her cancer diagnosis and had chosen to provide for the children of the marriage directly, leaving them 80% of her estate. I think a small amount went to her sister, but she chose not to leave the estate to the husband directly and then to let him use it as he see fit, but instead to provide for the children directly, and that wasn't disturbed on appeal. The other issue that comes up quite a bit is binding death beneficiary nominations, or BDBNs for short. As we know, these documents allow a member to direct their super to be paid to a nominated person upon their death, which may well be someone who's not a party to property settlement proceedings. So if a party to extant or unresolved proceedings that involve a super split becomes seriously ill, it's really important to ensure that a BDBN exists in favour of their legal personal representative, rather than nominating specific individuals, again, who might not be within the parties to the marriage, who would receive those entitlements upon death. For completeness, it's worth recalling that super is not an estate asset, which is why the BDBN needs to specifically nominate a person's legal personal representative and then have the super forming part of the assets, which then can continue the Section 79 or the Section 90 SM proceedings after the death of a party. And I think if we go to the next slide, the authority for that for that principle, I should say, is the matter of Stock, which held that a super fund trustee is not bound to follow directions of the will because super is not an asset of the estate. It's not the role of a trustee to involve real or perceived issues relating to a member's estate by paying death benefits, and that the fund does not pay death benefits to the estate unless there are no dependents or, this is the important thing for us, a valid BDBN in favour of the estate. So the other thing to note about BDBNs, going to the next slide, is that binding really does mean binding. So even if there are extant unresolved family law proceedings, a trustee is bound to follow a validly made nomination. The SIS Act at Section 59(1)A permits or allows the rules of a fund to provide for the making of these types of nominations, and the SIS regs state that essentially a trustee must pay them out if it meets the following criteria, which are really ones about them being valid and done in accordance with the regulations. The overall position is essentially that unless a BDBN directs payment to the deceased party's estate, that death benefit is not and cannot be property that would be the subject of a property adjustment order. It can't be set aside later under 106B, in case anyone's had that thought. The only reported decision that I've come across on this issue was a decision of Latour and Maddock, where it was held in respect to the wife's application that a BDBN made by the deceased husband in favour of his new partner could not be set aside under 106B because, according to the terms of the trust deed in that fund, the trustees were bound to pay the death benefit in accordance with the BDBN. Moving to the next slide, I've had cases before where I've needed to actually pursue a mandatory injunction pursuant to Section 114 of the Act, requiring a seriously ill litigant to execute a BDBN in favour of their LPR. I had a case some years ago now where the husband had a cancer diagnosis and refused to revoke or confirm that he'd revoked previous BDBNs in favour of his adult children of a previous marriage. We asked and ultimately got an order from the court in the form of a mandatory injunction that required him to make a new and valid nomination, so that if he did pass away before the proceedings concluded, the super, which in that case was very significant, could be dealt with under the current proceedings without the need to join third parties. Of course, the preferred option is that a party would volunteer to do this, but mandatory injunctions, whilst less common in our jurisdiction, are certainly possible, and the essential elements are often quite clear. If you think about your prima facie case, this is often, readily met because both parties will most likely have sought orders for the court to exercise its power and make some sort of super splitting orders under 90XT of the Act in their initiating application and response. So you kind of tick that off automatically. Damages will typically be inadequate if the super balance is a substantial portion of the pool, because as we know, you can't just put money into super. The balance of convenience is likely to favour the granting of an injunction to this effect because it's simply maintaining the status quo in the proceedings, and it avoids that complexity I referred to about having to introduce third-party recipients of any super under a BDBN into the proceedings. And I've extracted a quote from one of the main cases on mandatory injunctions, Films Rover, which holds, the court should take whichever course appears to carry the lower risk of injustice if it should turn out to have been wrong. And that is certainly the way that I argued the need for a mandatory injunction in that case. It might be a good time to pause and see whether we have questions from the audience directly or that have been popped through the chat, Dina.
I actually just had a question about the case you were just referring to. Did you say that you had the other parties sign the mandatory injunction in favour of the children, or was it in favour of his legal personal representative?
Yeah, he had an old or a valid binding death benefit nomination in favour of his adult children, and we'd written saying, could you please change that to be your LPR because you're unwell, and they've awkward letters to write, but we had to say we don't want to have to involve third parties to look. In that case, it was less problematic because both of the parties had met the condition of release by age. So it wasn't so much that once it was out of super, it couldn't be brought back. But it was more the complexity of having to join, adult children with whom our client had a fractured kind of relationship. So we said, we asked him to do it and he said no. And then we asked the court to order him to make that nomination, to change the old one, get rid of the adult children, and to instead nominate essentially his estate.
Great. Okay, some other questions there. So the basic one, when would you recommend using the base amount over the percentage order amount for a superannuation split?
Sorry, I had a hard time hearing that. Grace, did you catch that one?
Not quite.
No, sorry, it must be on my end. When would you recommend using a base amount order versus a percentage order in a superannuation split?
That's a good question. Grace, do you want to take that one, or would you like me to?
I think it's really the preference of your client and what the particular superannuation fund holds. So say if it's just an accumulation fund and you're able to reach an agreement on the exact superannuation split, then you would then be using a base amount. Otherwise, why would you use a percentage split over a base amount, Liz?
Yeah, I think it would be that sort of volatility in the changes in the values of assets. Sometimes I think I've used it where an SMSF isn't really up to date, and I mean, they should be, but this is the problem. They are self-regulated, and we've all had, non-compliant SMSFs in our family law matters. But I would say, and look, to be honest, you can kind of you can convert matters into an XT1A order by the use of a formula to achieve something that's equivalent to a percentage-based split. So my personal preference is to use the base amount pursuant to 90XT1A, unless there's a serious kind of volatility or specific reason to do with those underlying assets, as Grace mentioned.
Thanks for that. So we do have another question. So should lawyers be approaching superannuation splitting orders any differently when one of the parties is in the pension phase? Or should we be doing anything differently?
That's a good question. I would say you wouldn't approach the orders, the drafting of the orders differently, but I think you would approach the settlement differently, because the person who has met the condition of release can take lump sums out of super with no tax consequences. Grace, have you had matters where you've been able to kind of use that or leverage that?
Yes, definitely, because really it's more like cash rather than superannuation. So we would approach the settlement differently, particularly the split of the superannuation. We might not treat superannuation differently to the non-superannuation assets, as it
Yeah.
really is just like cash. So we might use a global pool approach rather than the non-super pool and the super pool approach, and just doing the same percentage division over the total pool rather than a equalization of super and a 60-40, for example, of the non-super pool. But the orders you would approach in the same way.
I agree with that. The other factor that might show up and that you might want to keep in mind is if there is a big age difference between the parties, and if the younger member of the fund has 10 or 15 more years worth of the ability to make contributions from employment, that might be a factor. As Grace says, you can still adopt a global approach, but you might say, well, there's no need to equalise the super now because the person who's older kind of needs it more and has less ability to, contribute because they're now in the pension phase. So sometimes those considerations, whilst making sure that you're still doing justice and equity on a global pooled approach, can sometimes just simplify the way in which the settlement's implemented. And if there's a fund that is not compliant and someone wants to keep it who's in the pension phase, that can sometimes present an opportunity to just sort of wash your hands of the whole mess.
Great. Okay. So are we going to quickly whiz through those case examples? Got a few minutes.
Yeah, great. If there are no more questions, we can have a quick look through those. Thanks, Dina. Okay, so as we know, the general approach is to equalise super in long relationships. What we've got is a couple of slightly more unusual cases where, for example, in a small pool or where assets that are in super far exceed what's outside of super. So we can whiz through the first one. Scenario A, husband and wife married for 30 years. At separation, husband's 67 and wife's 55. I forgot we put this one on the slide. The non-super assets is a home subject to a mortgage with a very modest equity. And the parties' combined super is $400,000. The husband's met a condition of release due to retirement and is drawing from super. And the question is, would the alteration of property in the usual way occur whereby you divide super and non-super separately? Is that appropriate? And I think Grace and I gave a spoiler alert. Grace, do you want to round that one off?
Well, no, as discussed just before, that the usual approach of treating super separately would really not be appropriate in this particular case study.
Absolutely. The next one, we've had husband and wife, again, long marriage, both retired at separation, non-super assets of 400,000 and combined super of 800,000. And in that, with that slightly different fact scenario, would you approach non-super and super separately, or would you adopt a global approach? And really, if they're both in the same position, you could simply operate on a single pool. I would say if they are both living essentially off their retirement savings, they're both going to value super a lot. So I don't think anyone's going to be doing a sort of cash for super split or swap in a case like this one. Everyone wants the super. It's interesting. You have cases where, you know, people are young and nobody wants the super, and they try and settle an obligation essentially to pay cash by offering a super split, and nobody wants it. But that, of course, changes as time goes on. And then the last scenario, we have husband and wife separating again after a long relationship, both in their late 50s, and it's the wife who's in receipt of or who's in pension phase, having retired early due to health difficulties. And the question is, how do you consider super in the pension phase for the purposes of affecting a payment split, and how would you approach the payment split? And I think this goes back to Dina, your or the question from one of our attendees, which is, well, if one person's in pension phase and the other's not, does that present an opportunity? For example, in we don't have the sort of the asset values in that case, but if someone's wanting to keep, say, a home and doesn't have the ability to borrow funds to, you know, buy out sort of an appropriate portion of the equity in that home, when in the pension phase a person is essentially receiving something that's equivalent to cash, there can be an opportunity to say, well, look, I'm 8 years away from, or 7 years away from super, you have it now, you take take a cash payment from super to give it to me, or in that scenario that I described, you would say, well, give me all of the non-super assets and you can keep the super because you're accessing it, you can live off it, it's not locked away for you. So you can, especially in smaller pools are always the hardest cases to settle. But if there are differences in conditions of release and eligibility in different phases for super, you can sometimes have an opportunity to do some creative things with the settlement.
And if you don't mind, we have just had one more question come through. Would you mind answering that?
Of course.
Sure. So it says, in a base amount split situation, how does the fund calculate the amount to pay if there's been a delay in implementation of the orders, e.g. if the operative time is triggered but the fund hasn't implemented the split and there's been a change in the fund performance in that intervening period?
That's a good question. I think this was on one of, or the provision was on one of Grace's earlier slides, because that does happen. It shouldn't, but it does happen. And the reality is they calculate it by reference to the regs, and it's to be calculated as at that date. Thanks, Grace. You brought that up now. Does that answer the question, or Grace, you might have something further to add to that one?
Yeah, so if there's a delay in the processing of the split, so for example, if the orders were made on the 2nd of January 2025 and the operative time is the standard 4 days after service of the orders, if service was effected on the 2nd of January, the operative time is set at the 6th of January. So even if the fund undertakes the split in, say, April, because of processing delays, as they often do, the date for calculating the quantum of the payment, whether it is a base amount or a percentage, is actually the 6th of January. So it's important to keep that in mind, which it's often why when the split is made, it's not exactly the base amount.
That's right. There's a good question, and thank you to the person that asked it, because it meant that we could go back over something that I think we skipped.
Yeah, we skipped
time. But you gave us a perfect opportunity, so thank you for that.
Great. Well, we might skip to the last slide now. Well, we actually have a few webinars coming up. So we've got one with Liz next week on Tuesday, and then we've also got Heather Gann from the Relations Space speaking to us on Thursday about borderline personality disorder. Thank you so much to our presenters. I've taken so many notes today. I've learned a lot about superannuation, which I feel like I should have already known, but I am walking away with a lot more knowledge than I had before. And thank you to all our members for dialing in. It's because you're involved that we're able to keep putting on really fabulous webinars. So make sure to keep registering, keep showing up, and we'll keep doing what we're doing. Thank you
Thanks,
again
Dina.
to Liz and Grace.
Thank you.
Thank you.
Thanks, everyone.
Bye.